So the Republicans are arguing that Paul Mitchell, the person who helped to draw these lines for the legislature, that he put Latino representation first and foremost. It was a racial gerrymander. It subsumed these other considerations. That's going to be a really hard argument to make when this was a partisan gerrymander. Everybody knows this was Democrats, stick it to Trump, all of that stuff. People knew this was a partisan issue. And so to say that race predominated, going to be a very hard case to make on these facts.
Let's talk about the lawsuit that's been filed by the California Republican Party against Proposition 50, citing two constitutional amendments that the plaintiffs claim are violated with Proposition 50. Take those one by one, please, Professor.
So, Proposition 50 itself is not being challenged in this lawsuit. There was a lawsuit before the election that argued Proposition 50 couldn't go on the ballot because of problems under state law. That went all the way to the California Supreme Court, and the California Supreme Court said, no, we're not going to take this case. And so that seems to be dead. The challenge now that was filed in federal court by Republicans today is not to Proposition 50 itself. It's to the maps that Proposition 50 pointed to that were enacted by the legislature. Now, we talked about how partisan gerrymandering doesn't violate the Constitution, or at least can't be policed in federal court. But racial gerrymandering can. And the main argument that's made in this lawsuit is that this is a racial gerrymander. And that's kind of a term of art. Let me explain what it means. It's a little bit complicated, but it's worth understanding what the Republicans are arguing here. So the Supreme Court has said that when you draw district lines, you cannot make race the predominant factor, the most important thing that you do when you draw your district lines, subsuming political considerations, traditional districting principles. And if you make race the predominant factor, it's got to be justified by a compelling interest, like maybe compliance with the Voting Rights Act. So the Republicans are arguing that Paul Mitchell, the person who helped to draw these lines for the legislature, that he put Latino representation first and foremost. It was a racial gerrymander. It subsumed these other considerations. That's going to be a really hard argument to make when this was a partisan gerrymander. Everybody knows this was Democrats, stick it to Trump, all of that stuff. People knew this was a partisan issue. And so to say that race predominated, going to be a very hard case to make on these facts. If it does, get that far, then the question would be, can the Voting Rights Act justify the consideration of race? And if you would ask someone like Paul Mitchell, why is he mentioning, in the lead up to Proposition 50, that the maps protect Latino voting rights? It's because Section 2 of the Voting Rights Act requires California to do that. And so it's going to be a hard argument to make. It could be affected by the Supreme Court's ruling that we're expecting at some point in a case out of Louisiana. We can get into that if you want. But it's going to be a hard argument to make just because that evidence is not there. The other argument is it was intentional discrimination against Latinos. It barely got a mention that violates the 15th Amendment. I don't think they're going to end up having anything serious to say about that. But there's one other really important point to note here, which is the timing point. The plaintiffs, the Republicans, in their lawsuit, they want to get a court moving really quickly and issue a preliminary injunction. That requires holding a hearing, having evidence. This is usually a many, many months process. And the Supreme Court has said, even in the context of redistricting, that federal courts should not be changing the rules as we get closer to an election. And the courts actually applied this rule called the Purcell Principle against both Louisiana and Alabama redistricting plans that were challenged as being illegal. And the Supreme Court said, no, this is coming too soon before the election. So even if Republicans have a meritorious claim, there's a decent chance that it's not going to be adjudicated in time for 2026 and would only apply if there were some change in the maps to 2028 and 2030.
Is Purcell, does it have some sort of time definite link to it, or what's too close to the election? How's that defined?
Well, I'm a big critic of the Purcell Principle. I actually named the Purcell Principle from a case called Purcell versus Gonzalez. It's not that principled as a principle. So the court has been inconsistent. It has applied this rule when the election was many months away. I think in the Alabama case, it was 9 months away. So we don't know what that period is. Initially, it was like the original Purcell case was out of Arizona, and it was weeks before an election. The question was about applying a voter ID law. That's when the court said there could be a lot of voter confusion, but the court has kind of extended this rule both temporally to longer time periods and to redistricting. So it's going to be, if the Supreme Court is consistent, they might say to a court that might want to put the maps on hold if they think the Republicans have a good chance, well, it's too soon, too close to the election, you got to wait for 2028. But more likely, that district court, it's probably going to be a 3-judge district court. It takes months for these cases to get going. And so by the time the court rules, maybe we're in April or May, and already, primaries are happening. People are running for office already. I saw that 2 Republican incumbents have announced they're going to run against each other, Young Kim and Ken Calvert, in the same district. So with all that reliance interest, I'm skeptical that the timing could work to actually have a challenge to the Prop 50 enacted lines in time for the next election.
Rick, back to the claim about using race as the principal factor for this redistricting that is implemented with 50. Is it implied or stated that the Latino identification of the voter is a proxy for being Democrat, or what? I'm trying to understand exactly how that's being linked, given that partisanship, the Supreme Court is not recognizing as a reason for it to jump in.
Larry, that's such a great question. And it shows you why this whole idea of racial gerrymandering makes no sense in places where partisanship and race overlap. So the big case that the Supreme Court's considering now out of Louisiana drew a second congressional district because they were told they were likely in violation of the Voting Rights Act by not creating a second black opportunity district for Congress. And the question the Supreme Court was addressing was, is race or party the most important thing here? How can you answer that question when 90% of black voters in Louisiana vote for Democrats and about 2/3 of white voters in Louisiana vote for Republicans? But the Supreme Court has said, this is what you've got to do. You've got to figure out if race or partisanship predominates. So one way you might do that is ask, do whites and blacks in Louisiana vote for different candidates in a Democratic primary, right? So that would take the issue of partisanship out of it. And so they try and look at that kind of evidence. Or could you draw a district that could be just as much of a partisan gerrymander that wouldn't, say, separate voters on the basis of race as much? So it's this weird kind of exercise that the Supreme Court has required jurisdictions to go through. And part of the reason for it is that some states were using Section 2 of the Voting Rights Act, which requires being race conscious and requires drawing some of these districts, as an excuse to draw lots of these districts, sometimes in odd shapes, and sometimes to accomplish all of these odd political goals. And the Supreme Court wanted to put a stop to that. And so in the Louisiana case, there's this tension between what the Voting Rights Act says, which is you've got to be race conscious, and the racial gerrymandering constitutional claim, which is don't make race the most important thing. And so we don't know, the court may end up even striking down or limiting part of Section 2 of the Voting Rights Act, which could have implications for this Prop 50 lawsuit, although again, probably not in time for 2026.
Hi, I'm Pat Morrison, one of the hosts of America at a Crossroads. If you like this video, don't just watch. Head over to our website where you can subscribe for early access to new programs, see our upcoming schedules, and connect directly with our guests in our weekly live streams. Thank you for watching.
Well, if that provision of the Voting Rights Act stands, though, it sounds like then that calls on federal courts to have to parse what is being race conscious, but not making it the principal factor in how you do redistricting. That's pretty significant hair splitting.
Courts have been doing that for about 25 years, and I speak to the federal judges that have to do it, and they know that it is not an easy job. And these cases, many of them are 3-judge courts, and that means you don't go to the Ninth Circuit, you don't go to the Fifth Circuit, it goes directly to the Supreme Court. So the Supreme Court has already heard 4 cases involving the question, is it race or party that predominates? I mean, it's absurd, but this is the standard, and yet they won't police partisan gerrymandering. So if you don't like partisan gerrymandering, like Republicans in California don't like partisan gerrymandering, or you're a Democrat in Louisiana, you don't like the Republican partisan gerrymander, that district was drawn to actually help Mike Johnson, the Speaker of the House, you claim it's a racial gerrymander because the courthouse door is open to that claim, but not open to a claim that taking partisanship into account is too much. And you get these weird things where people in North Carolina stand up and say, we're not looking at race data, we're trying to stick it to Democrats. We are engaged, literally the head of the General Assembly in North Carolina in the Rucho case, the case that said they're not going to police this. He said, I think good public policy is electing Republicans and not Democrats. I'm trying to draw lines to maximize the number of maximize the number of Republican seats. And he said, the reason I didn't draw an 11th out of 14 district for Republicans, I couldn't figure out how to do it. That's a defense to the law as opposed to an indictment of the whole process. So really, Congress has to step in and provide some sanity.
I'm going to be back with you next week, along with Janice, Mel, and Zev, as I'll be talking with former CIA officer Stephen Cash. He heads the nonprofit advocacy group, The Steady State. It's made up of former U.S. intelligence veterans who were opposed to President Trump's actions. We'll be with you again. That's 5 o'clock Pacific time next Wednesday, right here for America at a Crossroads. Make sure you make your reservation and sign up to join us with the link. Thank you so much. Have a terrific rest of your evening.